Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about something that involves what we call civil procedure in the law. We're going to talk about a motion to strike. I'll have more in just a minute. There is a rule that allows people to strike material from pleadings. Now, this is a copy of the rules from Tennessee, and it's their rule 12.06. It says, upon a motion made by a party before responding to a pleading, or if no responsive pleading is permitted, upon motion by a party within 30 days after service of the pleading upon him, or on the court's own initiative at any time, the court may order stricken from any pleading insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. Rule 12 says you can strike any insufficient defense or any scandalous or impertinent material. You don't usually have scandalous or impertinent material if lawyers do the pleading, but a lot of times when people act pro se, they put all kinds of junk in a pleading, and if it isn't ignored, somebody files a motion to strike it and it gets taken out that way. But basically what the motion to strike is a giant eraser. It allows you to come in and erase stuff out of the pleadings. So what's an insufficient defense? Well, I'll give you an example. In Missouri, we have a rule called the pleading rule, which is a fact pleading state. We have to plead sufficient facts in order to establish a cause of action. So, for example, when I plead a negligence tort, I have to plead that there was a duty, that somebody breached that duty, and that the breach of that duty was the proximate and legal cause of the injury to the plaintiff, and then also I have to plead damages. I have to get the elements of that claim in front of the court. And I have to do it with facts. I can't just say there were damages. I have to say the damages were so much, or the damages are of this type. Either way, I have to get that information in front of the court. A lot of times, defendants will offer what's called an affirmative defense. Now, an affirmative defense is different than saying you didn't get all of the elements, you didn't meet all of the elements. That's just a plain old defense. An affirmative defense is a defense upon which the party making that defense has the burden of proof. A good example is the statute of limitations. So, in Missouri, there is a 2-year statute of limitations on medical negligence claims. So if somebody filed a medical negligence action outside the statute of limitations, they have no requirement to put in their pleading that they're outside the statute of limitations. But a defendant can come in and say, this claim fails for basis of the statute of limitations. But in doing so, they have to plead facts, just the way the plaintiff does. So if you say this cause of action fails because it's outside the statute of limitations, that will not fly and is subject to a motion to strike because it is an insufficient defense. Therefore, when lawyers talk about a motion to strike under Rule 12, they're really attacking the pleadings. But that's not the only motion to strike that gets filed. Sometimes motions to strike are used to take other things out of the court file. For example, a lot of cases require an expert witness, a medical malpractice expert, for example. We need to have somebody to say, the doctor screwed up and here's why. If there is some problem with that expert's report, then there is a mechanism through which that expert report can be removed from the record, and you do that through a motion to strike or a motion to exclude. Most commonly, it's referred to as a motion to strike the expert's report. There are several reasons why this happens. Either the parties fail to submit a report when they're supposed to. Under the federal rules, they have an obligation to file a report under Rule 26. They filed the report out of time. They file the report and it's incomplete. It doesn't contain all of the information necessary to make it a complete expert report. Or there is some other lack of reliability about the expert's report. Maybe the doctor who is opining has an academic degree as a medical doctor, but suppose he lost his license for some reason. Or in some cases, some states have a requirement that the doctor has to practice within that state or within a contiguous state. And if they don't, then, well, you can't use that expert. So those are the sorts of things that cause experts and cause reports, that sort of thing, to be stricken. So in addition to striking pleadings, you can also striking expert opinions, you can strike portions of testimony. For example, where a lay witness offers an expert opinion that, for example, car was going too fast, or offers a legal opinion that that violates the law. The judge is the expert on the law, and he doesn't want to be in competition with a lay witness who probably doesn't know that much about it. In addition to that, almost any other kinds of testimony that's based on speculation or assumptions, that sort of thing, all of that can be stricken as inappropriate, again, subject to a properly filed motion. I want to talk real briefly about two cases. The first one is Bell versus Illinois Central. And I'm not going to bury the lead here. This is the end result. For the reasons set forth below, the motion to strike plaintiff's expert witness is granted in part and denied in part. The motion to strike defendant's motion to strike plaintiff's expert witness, June Blaine, is granted. The plaintiff's motion to strike defendant's motion to strike plaintiff's expert witness, June Blaine, is granted in part and denied in part. And plaintiff's motion to strike defendant's retained experts is stricken. Plaintiff's motion to strike Dr. Bernard Randolph is stricken. And you can see as we go down here, everything's either stricken or denied, stricken or denied, stricken or denied. Now, this is one of the reasons why judges sometimes hate lawyers. In this motion, defendant requests this court strike June Blaine as an expert. Plaintiff failed to comply with the court's scheduling order, in that the disclosure was deficient, in that a written report pursuant to Rule 26 was not received. Plaintiff responds that June Blaine doesn't fall under Rule 26 because she's not a, quote, retained, quote, expert, thus not requiring a report to be filed, and the court scheduling order does not address non-retained experts, but only retained experts. Well, that was a pretty dumb thing to do. And here's how the court resolved that. The court said, the court's scheduling order requires that all expert witnesses be disclosed, including retained and non-retained experts. Expert witnesses shall be disclosed along with a written report prepared for and signed by the witness pursuant to the Federal Rules of Procedure 26A. So they really had a terrible argument here, and they made a terrible argument by basically saying, no, boo-boo, we weren't covered, it was a non-retained expert, la 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 la. I don't think that kind of thing ever flies with a court. It looks like you're playing games, and they are very fortunate here because the court simply made some adjustments to its scheduling order and allowed them to go forward. And you have to just know that at the end of the day, the judge was like, ugh, what am I dealing with here? It's a good idea if you have a lawyer who has a good level of emotional intelligence. When a lawyer gets bogged down in fighting with the other lawyers, not over something that matters, over things that are basically ego-driven, it's not going to end up well for any of the parties. So you want to make sure that your lawyer is doing the right thing and not quibbling over stuff that just makes the other guy's life that much more difficult. One of the things that we frequently tell clients is if the other side asks for an extension of time, unless it's just clearly unreasonable, we're going to give it to them. And it's not because we want to extend the litigation, because we don't, but because we all realize that people have other things going on in their lives. They have to take vacations. Sometimes they have to travel on other cases. And as a result of that, we try to work with our opposing counsel. And the people who don't try to do that tend to be regarded as obstreperous, and they generally don't have as good an outcome as people who work with the other side to try to get the case to a resolution. And that's whether you have great liability or whether you have poor liability, you need to have a good relationship with the lawyers on both sides. So that was the Illinois Central case. Then we come to Salcato versus GM. And in that case, you have a lawyer who gets a deadline to disclose his expert witnesses and misses it. And he files a motion and says, can you extend the deadline? And the court said, okay, I will extend the deadline, but you absolutely positively have to have your experts disclosed by this date. If you don't, they're going to get dunked. So as you can see here, the court says in granting this second extension, the district court made clear the April 12th was the final cutoff date. This was a second extension. And unless reports were turned in by the 12th, the case would get dunked and plaintiffs would lose. And instead, the reports were submitted on Monday, April 15th, the next business day following the deadline. That is legal malpractice. So he's given until April 14th to disclose the experts, and he discloses them on April 15th. If you have a lawyer and you're in litigation, you always need to stay on top of dates. It's the most important part of what you do when you practice law. If the date that you have to do something is a certain date, if you do it after that, usually the result is bad. So if you are hiring a lawyer, it's a good idea to ask them to send you a checklist of all the relevant dates in the case. Get a copy of the case management order. Get a copy of any amendments to that and follow along and make sure that your lawyer is hitting the dates that are supposed to be hit in the case. That way you won't get a motion to dismiss or you won't get a motion for summary judgment as was filed in the GM case. And the judge basically told them, look, I told you I was going to can this case. If you didn't give me the experts on the right dates, you didn't do it, so I'm granting the defense's motion. And of course, the plaintiff did what any plaintiff would do in that situation. They went up to the Seventh Circuit and said, hey, these guys are being unreasonable. This judge is just completely unreasonable. I only missed it by 1 day. And the Seventh Circuit told them, no, you missed it after the judge told you that this would happen if you missed it. So we don't feel sorry for you. Take a number. Anyway, that's what motions to strike are all about. That's how they're used. And they can be an effective tool in litigating cases like this if you know how to use them. But they also can be a death knell if you don't pay attention and you don't get your disclosures made in a timely manner. While we're talking about dates, I want to talk about one other little thing, and that is a lot of times lawyers will provide their clients with a new client packet, and in that packet is a series of questions and requests for information about when things happened and what documents you might have that reflect any of the concerns that you had about your particular case. If it's a contract case, they're going to want to see the contract. If it is an insurance case, they're going to want to see the insurance policy. All kinds of questions that go to what's wrong and why you need to be helped by the lawyer. What is your case about? They'll ask for receipts and a lot of middly-piddly stuff that just really seems like they want to know everything in the world about you, and you're probably just not that into your lawyers that you want them to know every little thing about you. But it isn't really your lawyers who want to know every little thing about you. It's the other guy's lawyers who want to know everything about you, and they are going to be serving interrogatories and requests for production on your lawyers once the case starts going. And so naturally, they're going to ask about everything that has ever happened to you in your entire life. Now, lawyers kind of work out exactly what questions are going to be answered and which ones are going to be objected to and which ones we're going to have to get a ruling from the court on. But the more information that a lawyer has, the easier it is to get those documents responded to in a reasonable amount of time. You have to get your responses in by a fixed date, just like you do with expert witness reports. And if you do not, there can be consequences for that. For example, objections that you might have might wind up being lost. So, again, if your lawyer asks you to fill out forms and get them paperwork and get them documents, do it and do it as quickly as possible because it will eventually help you when you're in the litigation stage of the case. You won't get 16 phone calls asking about this document or the other document. So hopefully that answers some questions about motions to strike and this whole period that goes into the part of the case before trial. If you have any questions, leave them in the comments down below. Otherwise, do all the things I ask you to do and everybody else asks you to do on YouTube. Like, share, subscribe. If you know somebody who might be going through a tough time right now, reach out to them and help them. Give them a little bit of moral support, especially if they're going through a lawsuit or a case. It's a difficult time and it puts a lot of demands on you. Remember, there's absolutely no price on being kind. Thank you so much. Have a great day, and I will catch you on here next time.